everyone. Thank you very much for joining us today for our webinar. My name is Dustin Saldarriaga, and I'm an immigration attorney with Scott Legal PC. We're going to spend some time today talking about the EB-2 National Interest Waiver, or NIW, green card. This is an underutilized category and one that we've actually started to see more and more people use, especially entrepreneurs. A few things before we get started. Our firm is a full-service immigration law firm with a focus on business immigration. However, including visas in the NIW category. However, we do also assist with family immigration matters, temporary visas, and really any immigration issues or questions that you might have. So please do reach out if you have any questions at all. We will continue this webinar series by doing at least 2 webinars a month, and our webinars are on a variety of topics. At the end of this webinar, I'll be sending out a few things. We'll send a PowerPoint, the PowerPoint presentation that you see on your screen. We'll send a comprehensive guide on the National Interest Waiver that you'll learn about today. And we'll send a link where you can sign up for future webinars. In terms of our panelists today, we are very fortunate to have Kelly Legrand-Wiener with us to speak. Kelly is the managing attorney here at Scott Legal. She has vast experience in the area of national interest waivers as well as business immigration generally. I will be your moderator. If you have questions, please do feel free to send them through the chat box function on Zoom or through the Q&A function. I'll be monitoring both, and I'll either be sharing them with Kelly during the presentation if they're especially relevant to what Kelly's speaking about, or I'll save them for the end. But either way, we will get to your questions, so don't hesitate to share them with us. Finally, the webinar will be recorded and will be made available through the follow-up email. You'll get a link to where you can watch the video. We'll also upload our video recording to our YouTube channel. So I do encourage everyone to check out our YouTube channel. We post our full webinars on our channel as well as shorter videos on a huge variety of immigration topics. So it's a great and free resource. So without further delay, I will turn it over to Kelly.
Thank you, Dustin. So as Dustin mentioned, we'll be talking about the National Interest Waiver today. And you know, this category previously was underutilized. Before 2017, there was a different legal standard than the one that we'll talk about today. And the new legal standard that's in effect was a case called Matter of Danazar, and really opened up the NIW significantly from where it had previously been. And particularly, there's language in that case that we'll talk more about that made this a very attractive option for entrepreneurs, whereas previously, I think really entrepreneurs didn't look at this as a viable category as much. There's been a lot that's happened over the past few years to make it a more attractive category for entrepreneurs. So what is the National Interest Waiver? The National Interest Waiver is a subcategory of the EB-2 employment-based green card. The National Interest Waiver just means the waiver of the job offer and labor certification requirement that's in effect for the normal EB-2 category that you think of. A benefit of the NIW is you can self-petition for a green card without any job offer from a U.S. company, and you don't need to go through the labor certification process where a company tests the labor market to determine if there's any willing, qualified, and available U.S. workers. Essentially, when you apply for this category, you're asking the government to waive that requirement. So let's look at the specific requirements listed here. As a threshold requirement, you must show that you have either an advanced degree, so a master's or higher, or its equivalent, which would be a bachelor's plus 5 years of post-baccalaureate progressive work experience in a relevant field. If you do not have a degree, you can also potentially qualify based on exceptional ability. Exceptional ability is defined as a degree of expertise significantly above that ordinarily encountered in your field. I want to contrast this quickly just with the extraordinary ability category, which sometimes these two are confused. Extraordinary ability is a much higher standard, referring to an individual that is one of a small percentage who's reached to the very top of their field and has sustained national or international acclaim. Exceptional ability, I think for people that are kind of very, you know, high up in their field, perhaps don't feel they've reached that extraordinary ability, test yet. Exceptional ability is something that could be in your reach. Sometimes that makes the national interest waiver a more attractive category if you don't feel yet that you can qualify for the EB-1A extraordinary ability green card. So something to keep in mind. If you are qualifying based on exceptional ability, you would need to show that you meet at least 3 of the 7 criteria listed here. So I won't list them all out, but as Dustin mentioned, you'll get a copy of the PowerPoint that will kind of go over each of these. One thing to keep in mind with exceptional ability is it does go through a 2-part test. So USCIS will first look at whether you've met the plain language of the criteria. So for example, membership in a professional association. Have you shown that you have a membership in a professional association? But then they'll also look, the second part is where they look holistically at whether that shows that you have a degree of expertise significantly above that ordinarily encountered. So if you have a membership in a professional association, but anyone in your profession could get in by just paying a fee and being a member of that association, that's likely not going to meet the second part of that test to show exceptional ability. You would want to show a membership in a professional association that's really limited to people that are at the top of their field. Perhaps you have to meet certain criteria or have certain accomplishments or be invited into that association based on your accomplishments. So those are things to keep in mind if you do need to make an argument on exceptional ability. So once we get past that threshold requirement, then we're going to look at the standard for demonstrating you qualify for a national interest waiver. So for the first prong to qualify, you have to prove that your proposed endeavor has both substantial merit and national importance. So you want to consider just as examples of things that, people have done successfully. Are you developing a particularly, good type of technology? Are you doing services in some, emerging or critical area? For example, cybersecurity, other things that have, clients of ours, perhaps you consult with the government on kind of counterterrorism initiatives. What you want to do is kind of separate out what you're doing, what your proposed endeavor is, and then ask yourself, will the government find this important? Will the government find that this has substantial merit and national importance? For the second prong, you want to show, who you are. Why are you well positioned to advance this endeavor? So you're going to look at your history. What does your education show? What is your track record in the specific field that you're trying to work in? Especially if you're an entrepreneur, have you done this type of business before? Have you successfully, run this type of enterprise? How far along is your endeavor? What have you done to advance it? Is this going to be a viable endeavor? And are you as the individual going to be able to do what you say you're going to do? So that's where you want to look at what is your track record in the field. And we'll talk a bit about this later because it is possible to apply for the NIW as an entrepreneur with a pure startup. However, if you have a track record of success as an entrepreneur, that's going to be much more compelling in terms of qualifying for the NIW. And then the third prong is that there has to be a showing that on balance, it would be beneficial to the US to waive the requirements of the job offer and the labor certification. So for entrepreneurs, one thing that, one argument that can be used is that the normal labor certification process is really not set up for entrepreneurs. If you are a majority owner of a company, it's very unlikely, sometimes even impossible really, that you're going to qualify based on a normal labor certification. The way that the system is set up wouldn't really permit it. So you can argue that in an NIW to say that the normal labor certification process is not going to work for this entrepreneur. Another thing you can argue is that it's in the government interest to make sure that US workers are getting jobs. You can also point out that even if there are other people in the US working on this particular endeavor, the endeavor itself is so critical that it merits waiving the labor certification. So there's kind of different arguments you can use to meet this this third prong. Go to the next slide. So how the national interest waiver can be used for entrepreneurs. It used to be that under the old standard that, the endeavor needed to show that it was national in scope geographically. The change in matter of Danisar is they explained that, geographic area can be important, but you can still show national importance even if you're only having a local impact. So for example, hiring employees in a local area that has, that's economically depressed or has, a lot of unemployment, that can still be considered of substantial merit and national importance, even though it's not national in scope from a geographic perspective. Other things, that are, beneficial from Danisar, they specifically pointed out that entrepreneurs as self-employed individuals are, not eligible for green cards under the labor certification requirements. So the very fact that it is impractical and impossible to get a green card through this method is something that was pointed out in Danisar as a reason why, could be used, to qualify for the national interest waiver. Danisar also specifically notes that entrepreneurial work can lead to a national interest waiver. And they also put in something that's helpful for startups, which is to say that they don't need to know that the planned venture is 100% going to succeed. They acknowledge many entrepreneurial ventures ultimately fail, but as long as the applicant can show that it is more likely than not to succeed, it is approvable. So I think that really opened it up for startups to be considered, as a viable route for the national interest waiver. You don't need an established company. While it can be, of course, helpful to show that, you can apply with a startup, but in that case, you really would want to show that you as the applicant have a history, a track record of being successful in this type of venture that you're starting up. All right, so let's look at timing considerations. So there was some good news this year for national interest waivers. For a long time, national interest waivers could not take advantage at all of premium processing. In the past year, we've seen some progress on this, and most recently an update on September 15th said that premium processing will now be available for national interest waiver applications that were filed on or before February 1st, 2022. What this means is that the government will issue a response within either, an approval, a denial, a request for evidence, or a notice of intent to deny within 45 days. There is a bit of a caveat. They've said that they'll start the 45 days once they determine they have everything they need for adjudication. So they've built in a bit of room for themselves where they may be a little bit longer than 45 days if they feel that they haven't received all the documents they need to start the adjudication process. Additionally, if you get a request for evidence or a notice of intent to deny, then you'll need to submit additional documents, and then they would have another 45 days after receiving that response to issue a final decision. I'd say, still rolling out the process, and people that are filing new petitions as of today are not able to take advantage of premium processing. This is still only for applications that have already been filed, but it is progress, and we do expect that, they'll continue to roll out premium processing for national interest waivers, so that will continue. However, if you're considering applying for national interest waiver today, the timeline that you're facing is probably over a year to see your petition approved. Timelines are 14 months, 18 months. You want to think to yourself, if you're here on an underlying visa status, if you have a visa that doesn't allow for dual intent, like a TN or one of the e-visas, you just want to think about the timeline for when you're filing your I-140 petition. Do you want to renew your visa before you file it, so you don't have to kind of answer questions about any immigrant petition that is being filed? And then, for certain certain types of visas like the TN, once you have an I-140 filed, it really may not be possible to renew it. The E is a bit more flexible, the O1 as well. Sometimes we call these quasi dual intent visas. They don't have the full benefits of the H and the L visa in terms of allowing for dual intent. However, there is some beneficial language in the Foreign Affairs Manual and in various policy manuals over time that have indicated that once you file the I-140, that doesn't necessarily mean you cannot renew your visa. It's just something you want to work with your immigration attorney to make sure that you're positioning it in a way that you would still be able to renew your visa despite kind of the I-140 filing. The I-140 petition, just filing it alone doesn't give you any status in the United States. So if you do want to stay in the United States, you have to have some other type of underlying status, or you would need to be concurrently filing your I-140 and your green card application at the same time. So let's talk a little bit about the application process. The way that this works is you would submit your I-140 with all the proof that you meet those EB2 qualifications we talked about in previous slides. So proof of your degrees, if you're doing exceptional ability, proof that you meet those 3 out of 7 criteria, and then all the proof of that you meet each national interest waiver requirement. So those, that's generally going to be quite a voluminous package of information. And we'll talk a bit more about what's included later in later slides. Depending on whether there's an immigrant visa available in the EB2 category, let's say that you were here on an E2 visa running a company and the EB2 is current, you do have the option to potentially file the I-140 and concurrently file the I-485 green card petition. There may be reasons that you don't want to do that because once you file the I-485, you can no longer travel on your E2 visa. It's additionally then if the I-140, which takes a long time to pen, is ultimately denied, now you have, you've shown that you have immigrant intent by filing the I-485. So it may be that you want to wait until you know that you have that I-140 approved until you file your green card application. You can file the I-140 and choose to consular process abroad to get your visa. If somebody is, when we look at kind of pros and cons of adjusting status in the US versus consular processing, and which do you want to do? If you live here in the United States, if your family's here, they go to school here, your spouse is here, primarily this is where you want to be, generally adjusting status is going to be, a better option for you. If you're somebody that needs to travel internationally frequently, perhaps your family's outside the US or they travel a lot as well, you're not okay with having a period of time where you kind of need to stay in the United States, then you may want to go with consular processing. The reason being that once you file your adjustment of status I-485 application, unless you're on an H or an L, you have to wait until you get a travel authorization approved, and that can take several months. So you would need to be comfortable staying in the United States for several months, and not everyone is open to or able to do that. All right. So something that has been, beneficial over the past year, besides just the matter of Danazar, which happened in 2017, and then over the past year, we've had even kind of more beneficial things happen for NIWs, in that there have been updated guidelines issued for kind of STEM professionals and entrepreneurs. So this is another indication kind of from the government that they want the adjudication standards to take into account these types of individuals as eligible for the national interest waiver. So when we look at STEM specifically in the area of national importance, there's a list of critical and emerging technologies. So this is, endeavors that aim to advance STEM technologies and research. And this is very helpful to show, that you have an endeavor of substantial merit and national importance if it's on this list. Additionally, if you are a STEM advanced degree holder, this is viewed as a favorable thing for meeting that second prong, for showing that you are well positioned, to advance the endeavor. When we look at the entrepreneurs, Specific language was included in the USCIS policy manual to explain that the substantial merit and national importance can be supported by media attention on the petitioner or the business or both, awards and grants from government entities, any kind of third-party industry actors, including they spoke specifically about investors, venture capital, that can be really helpful to show that some third party within your industry who has this expertise finds your endeavor to be valuable, and that can support substantial merit or national importance. Additionally, any letters from government agencies, if there's revenue generation that can be shown, any job creation and growth of the company, those are all very helpful. Specifically also to show that you, the individual, are well positioned, ownership and a critical role within a company can be utilized. Degrees, certifications, any letters describing your professional experience, so some of the evidence from the substantial merit and national importance is going to kind of overlap with well positioned. So if you show there's interest from investors in your company, that's very helpful. If there's been participation in incubators or accelerators, especially if they're well thought of in the industry, that can be very helpful. Receiving government grants, if there's any IP of the applicant or of the company. And then similarly, media attention, revenue growth, or letters from third-party reviewers. For example, if you have a product that's in a testing, place, and you have kind of large, retailers or wholesalers that want to purchase it, and they have, they're willing to write a letter explaining that, that can be very helpful. So all this language was added to really help, adjudicators to figure out, okay, we can include this can be part of our analysis, whereas perhaps previously, prior to 2017, they weren't seeing a lot of entrepreneur NIWs. So some of this evidence that's relevant to entrepreneur NIWs was not as relevant prior, but now the government is telling adjudicators this will help meet the standard. Okay, so let's talk about what is included in an NIW submission. These generally are extremely voluminous applications. The government will take your word for nothing. You have to provide objective proof of kind of everything that you, put forth in your support letter. So for example, if you, explain that your work has been featured in the media, you need to include the proof that it actually has been featured in the media. And if that media is not very well known because it's specific to your industry, so it's very well known or very well thought of in your industry, but perhaps not so much in the mainstream, you need to include that background information so that the adjudicator can understand, why it's important that it was included in this media, and that would have needed to be very high level to even be considered. When we look at kind of those threshold requirements, you're going to include copies of your degrees, copies of your certified transcripts. If you are relying on the bachelor's degree and work experience, you would include the bachelor's degree transcripts and, signed employment letters from, prior employers showing that progressive work experience. If you're doing exceptional ability, then you're going to have, lots of documentation to support that you meet at least 3 out of the 7 criteria. But if you're relying heavily on exceptional ability, you really want to be showing you're meeting as many of those criteria as possible. So then when we move to the National Interest Waiver, you'll need to have, a detailed statement about your proposed endeavor. What are you doing in your business? What are your intentions? If you're kind of developing new technology, for example, you want to outline how that's going to improve the field, on an industry-wide level, ideally, explaining why, your work is of substantial merit and national importance. There should be kind of, proof that the public or the government is interested in the work that you're doing. There can be news articles, statistics, government reports, market reports, any documentation, of experts writing about your particular endeavor. If you're an entrepreneur, you want to include a comprehensive business plan that outlines, why your particular proposed endeavor has substantial merit and national importance. For the expert letters, these are very important for 2 prongs, both to demonstrate substantial merit and national importance, and they can also be used to show the applicant is well positioned to advance the endeavor. Some expert letters will be able to be used for both. Some may just be used for one prong or the other. You want for your expert letters, these are not kind of recommendation letters, that the way you normally would think of them, with somebody coming and saying, yes, I've worked with this person and, they're great. They really need to be significantly different than that. So first of all, you want the expert letter to establish that the individual who's writing it is an expert in the field. So why should the adjudicator listen to this person? So you want kind of the letter to establish that. And then you also generally will include, the resume of the actual expert, confirming the information that they're writing in the letter. Then they need to explain kind of, once they've established that they're an expert, how do they know you? How do they know the applicant? If they're writing to explain why they think you are well positioned to advance the endeavor, they should really, outline particularly your accomplishments within the letter. You also want to have, kind of a view as to why they think what you're doing has substantial merit and national importance, and why you as the applicant are, well positioned to advance that endeavor. For entrepreneurs, you may also want to include letters of interest from investors, future clients that want to work with you, anyone that wants to collaborate with you within the industry, particularly if they're kind of high level or well-known companies. Those are very helpful, both to show that your endeavor has national importance and that you yourself are well positioned to advance it because they're interested actually in working with you. Additionally, for the applicant, for the well-positioned prong, you want to include your resume, your degrees, proof of your professional accomplishments, if you have any patents, if you've won any awards, if you are a frequent, presenter at industry conferences, any media recognition that you've received, as well as evidence of kind of your past history of success in the field. These are very important to show that, you are well-positioned to advance the endeavor. Another thing that sometimes is helpful for entrepreneurs, besides kind of these proof of contracts, letters of intent, and startup capital, sometimes is an economist report that will speak about job creation. So showing that there's an economic benefit, to the United States based on kind of, your particular business. So that's something else that can also be included, when you apply for the National Interest Waiver, just to help show, kind of substantial merit and national importance within the entrepreneur context. Okay, so let's look at a case study for entrepreneurs. So this applicant, was an entrepreneur who had a small consulting firm to work on projects focused on improving services to U.S. veterans. This petition was initially denied and then was approved at the Administrative Appeals Office. So the, and kind of the case is a good one in the sense that it shows the Administrative Appeals Office really setting out, why it was that this person qualifies as an entrepreneur, what particularly they did to meet each of the prongs. So there were, lots of expert letters, news and media articles, and research reports on kind of returning veterans having a difficult time and the substantial merit and national importance of supporting, these people as they came back. So there was lots of, support for this kind of from multiple areas. So both in kind of major media, also in kind of charitable and philanthropic areas, the nonprofit industry, as well as from the government. So they had kind of multiple areas of kind of people confirming this is something that's really important in the United States. So, letters from experts, letters from, leaders in the military, government, business, and charitable institutions, all kind of were very compelling in showing the substantial merit and national importance. Then they looked at kind of this person's particular work. So this person had prior success in this area, prior success in doing exactly what they said they were going to do, which is, helping, returning veterans, providing some of these letters were probably, you can see kind of were used for multiple prongs. So, for the government officials, they spoke not only about the importance of the endeavor, but also about why this particular applicant was well positioned to advance this endeavor. So what success they'd had in the past, that they actually had demonstrated that they were able to work with various agencies to get a lot of money funded for various programs that did actually impact veterans in a positive way. So that those attestations of prior success were really key. Additionally, a comprehensive business plan that kind of went over the planned activities, included all the descriptions of what the company would be doing, including detailed financial assumptions. So it was not only that, they had these outside experts, saying this person has done this successfully in the past, but they also had a demonstrable plan that made sense and an explanation of the financing that made sense to show that this really would be an endeavor that, was more likely than not to succeed. So those financial statements that showed sufficient startup capital to fund the company, and that it was a reasonable business plan were also very key, in moving this forward, as well as that part showed potential clients. So there were actually people that wanted to work with him, on these projects. In terms of the third prong, because this person was an entrepreneur and self-employed, he was able to argue that it would have been impractical to obtain a labor certification. It wouldn't have been possible given the current setup of the labor certification structure. Additionally, the value of the services that were going to be provided and the track record of success showed that even if there were other U.S. workers doing this work that were qualified to do it, the U.S. is still going to benefit, from this person's, contributions. So I think that's, kind of gives you a good sense of kind of what needs to be included, when putting together these types of petitions. But it's also good to keep in mind this case, although, as it was outlined by the Administrative Appeals Office, ultimately was quite strong and met each of their requirements, was still denied initially and then needed to be appealed. So when you are doing an entrepreneur NIW, you do want to make sure that, you're covering your bases. These are not easy petitions to get approved, although the standard has become better, has become much more friendly to entrepreneurs. It's still something where you're going to need to submit a large amount of evidence, a large amount of compelling evidence to show that you meet each of these criteria to qualify for the National Interest Waiver.
Great, Kelly, thank you so much. So we actually have not received any questions so far. So I will go ahead and give our wrap-up talk. We are ahead of schedule. So if while I am, can you hear me okay, Kelly? Okay, perfect. So if while I'm saying this, any questions roll in, we can address them. But I did just want to quickly reiterate what I said at the beginning, which is that we'll be following up this presentation with a copy of the PowerPoint that you see on your screen, a link to the recording, which will also be on our YouTube channel, as well as a link to where you can sign up for future webinars. So Kelly, a question has rolled in. How much capital is typically required for the EB2 NIW visa?
So it's not like the EB5 where there's an amount of capital you can invest and that will make you qualified. It's really going to depend on the type of enterprise you're starting. So it should make sense in light of your business plan. For example, a business like a consulting business is probably going to need less startup capital than a business that is developing some type of technology and it has to go through beta testing, or perhaps has lots of inventory and needs warehouses. So it's going to be dependent on the type of business that you're starting. But I think generally, especially if you're looking at relying on kind of interest from investors, a higher amount is going to be more compelling than a lower amount.
Perfect. All right. Well, Kelly, thank you so much for taking the time and sharing your expertise. And to all of you who have attended today, we thank you for taking the time. Do keep an eye out for that email that I mentioned, and we hope to see you at future webinars.
Thank you. Have a nice day.